Hearing in the appeal, Candey Ltd against Crumpler and another.
Mr. Lord.
Morning, my lords. I appear with Mr. Saul, Queen's Counsel, and Mr. Ryan on behalf of the appellants. Mr. Holland, Queen's Counsel, and Mr. Robbins appear on behalf of the respondents. And my lords, as far as the bundles are concerned, I hope you have a key documents bundle, which I believe you have in hard copy. There's then a core volume and authorities bundle. There was a supplemental bundle lodged on Friday.
Yep.
There's a 3-page supplemental key documents bundle that contains the fee fixed agreement, the terms and conditions, and the deed of charge, which is obviously also in the core bundle, but we thought that would be convenient. And I believe my learned friends instructing solicitors sent a couple of further authorities through on Monday, I think it was.
Yes, I think that's right. I should say we have hard copies of the first of the key documents bundles, but apart from that, we're working electronically.
I understand, my lord. Yes.
And I hope you don't mind if some of us work entirely electronically. In other words, I'm not planning to use any hard copies unless I have to. So
I don't mind at all. I'm just very impressed because I find it incredibly difficult to work electronically. The timetable, we've agreed a timetable subject to your lordships. I think I'm supposed to stop at 3 o'clock today, and then Mr. Holland will go until 3 o'clock tomorrow.
Yep.
There is a live transcript being taken. Sorry, yes. There is a live transcript, so if it's convenient, I think we'll have a short 5-minute break at a convenient moment in the morning.
Yes, for the stenographer's sake, yes.
Now, my lords, as far as the format of my submissions are concerned, I propose to briefly mention the facts and identify the relevant documents, then take your lordships to section 73 and the key authorities, which are really the authorities referred to in the Court of Appeal judgment, and then address your lordships on the test, and then go through the issues in the following order: the relevance of independent legal advice, whether or not the Court of Appeal were correct to infer an intention to waive the lien as a result of inconsistencies, addressing the 4 inconsistencies in turn, then the question of reservation, then post-liquidation waiver, abuse of process and discretion. As far as the facts are concerned, they're set out in the statement of facts and issues. Unless your lordships want me to, I wasn't going to go through that in any detail.
No, you can take it. We've read the SFI and the judgments below, and also the precise 50 pages of each of the different cases.
Yes, my lord. Just very briefly, PHRL was in a parlous financial position, and the fixed fee agreement was in effect the only way it could continue with the litigation, and it required Candey to sign up to that and to take the risk and to support it. And the relevant events are described in Mr. Candey's witness statement, which are in tab 7 of the core bundle at appendix 15. I'm not sure if your lordships want to look at that. It's really paragraphs 10 to 18. But he summarises the various matters on which Candey were working, the difficulties in obtaining any finance, and the circumstances in which Candey signed up to the fixed fee agreement, and indeed PHRL did.
Can you give us the page number for that?
Yes, I can. It's pages 3 to 8 is where. Sorry.
I think the witness statement begins at page 370.
Sorry, yes, 370 is where the witness statement begins. 372, paragraph 10, is a summary of work being undertaken. Paragraph 14 on 373, he sets out the various matters on which Candey were working. And then paragraphs 17 and 18 are worth reading. In addition to Candey's lien and other rights arising by operation of law or in equity, and in view of the number of foreign jurisdictions in which Candey was acting, it was considered prudent by myself and my partners to enter into a parallel legal charge to further secure the fee liability and outstanding costs. That charge did not contain any claim for interest, which was instead provided by the fixed fee agreement. Contrary to what Mr. Crumpler suggests, at no point did Candey or PHRL seek in any way to suggest that by entering into the legal charge, Candey would waive, forfeit, or otherwise lose or relinquish any other rights it might have, including the right to be paid out in the proceeds of the litigation which Candey was conducting. In fact, it's a matter of record that in particular Candey expressly reserves such a right. My Lords, as far as the documents are concerned, if your Lordships have the 3-page supplemental key documents bundle.
Do we know what the deponent means by saying it's a matter of record?
I think what he's doing is presupposing my arguments on reservation. What Mr. Candey is referring to is in effect our position, which is that even if there were inconsistencies from which your Lordships could infer an intention to waive, Clause 7 of the fixed fee agreement contains an express reservation. Okay. Mr. Candey also explains that he said to Miss Crumpler that Candey would be paid first. So the fixed fee agreement...
I'm just looking at this. So there is, in paragraph 24, he refers to an express possessory lien.
Yes.
In paragraph 25, is...
That's the reference to Clause 7 of the fixed fee agreement.
Yeah. Yes, okay.
We'll look at these provisions in more detail when we come on to consider the question of reservation.
Yeah.
So, my Lords, as far as the fixed fee agreement itself is concerned, that's in tab 1 of the supplemental key documents bundle. Clause 1 provides this agreement is made between Candey and PHRL and is subject to the attached standard terms of business. To the extent any of those terms conflict with this agreement, the terms in this agreement shall prevail. This agreement supersedes and replaces any previous agreement between Candey and PHRL. By signing this agreement, PHRL confirms that it has obtained independent legal advice in respect of this agreement, and it accepts that Candey is not providing advice to PHRL in respect of this agreement. PHRL also agrees that it is not acting under duress or any undue influence and waives any rights, having obtained legal independent advice to contend that it is. 2 provides that Candey will continue to act in the various matters. 3, the final sentence, the last 2, Candey's previous estimate of costs has been revised to 5 to 6 million. Actual figure could be significantly higher or lower if there's an early settlement. 4 provides for the fixed fee, and you can see on the 3rd line, £3,860,637.48. And then it's agreed that to assist PHRL's cash flow, PHRL is not obliged to pay before judgment on liabilities handed down or settlement. And then the final sentence, interest at 8% per annum will accrue from judgment or settlement. 5 provides that in addition to the fixed fee, pay Candey's outstanding unpaid invoice costs. And then 5 lines down, the fixed fee excludes all disbursements. 7 is the clause that Mr. Candey refers to in his witness statement, which we say amounts to a reservation. Any monies recovered by PHRL from the date of this agreement will be applied by Candey towards the outstanding costs and or the fixed fee and or disbursements at Candey's discretion. And 11 says that as continuing security for the payment and discharge of all liabilities due from PHRL to Candey, PHRL shall execute a deed of charge and security in the former annexed. And then behind tab 2 are Candey's terms and conditions. I'm not sure we need to look at any of that, but...
Page number, please.
Page 3.
Thank you. Well, is that the electronic page number?
It's 3 in this, in the...
Page 4, I think, electronically.
Oh, this document is not.
I'm so sorry.
I'm sorry, my lord. It only appears in this three-page document. I'm not sure we're going to be particularly troubled by it. The only point I was going to point out was the point that Lord Reid mentioned to me, which is clause 3, invoicing, the final sentence. We are entitled to retain all papers until our fees are paid in full, which is a reference to the possessory lien. And then behind tab 3 is the deed of charge and security, which for Lord Briggs is page 291 of the core bundle. And as continuing security for the payment and discharge of all liabilities to Candey pursuant to the fixed fee agreement, PHRL hereby charges to Candey, 1, by way of fixed charge, all assets and undertakings of PHRL, 2, by way of fixed charge, any and all damages, costs, monies or other sums and or benefits flowing from all claims, including the specific claims set out in the fixed fee agreement. 3, by way of floating charge, all such or further assets belonging to PHRL that are not today capable of being charged by way of fixed charge. And say for the deed of charge dated 25th of March in favour of Campion Maverick, PHRL warrants and agrees it's not created and will not create or permit to subsist any other security or charge over the rights or monies. And then 5 and 6, which we'll look at in more detail later, PHRL irrevocably agrees and instructs Candey to act with full powers to ensure that any monies or benefits arising or payable in any court proceedings in any jurisdiction shall be paid directly to Candey towards payment and discharge of any liability pursuant to the fixed fee agreement prior to anyone else, save for the repayment of any bona fide liability due to Campion Maverick. And in the event that any of PHRL's rights, titles or interest in or to any monies or benefits covered by this deed are assigned or awarded to a third party by court order, or such monies are otherwise paid to a third party, that third party shall receive such money subject to this deed and subject to the discharge of all liabilities to Candey pursuant to the fixed fee agreement. Now, my lords, PHRL went into liquidation on the 8th of February 2016. And Candey's proof of debt was lodged on the 19th of February 2016. And the proof of debt is in the core bundle, tab 7, appendix 14, page 356. And that proof of debt refers to the deed of charge that we've just looked at, but makes no mention of the equitable lien or section 73. My lords, then there was a settlement of the main proceedings in London, and the order of Mrs. Justice Asplin approving that settlement is in the core bundle at tab 8, page 386, and at page 387 you see 1, the claimant shall repay to the third defendant the sum of 50 million. Claims and counterclaims are dismissed. Injunctions are discharged. And then 4, the sums paid into court in respect of security shall be paid out as follows: 750,000 to the first defendant, 750,000 to the third defendant, all remaining sums to the claimant. Sums paid by way of fortification shall be returned to the claimant, and then provision for costs. And it was as a result of that that the liquidators received the sums of 10,013,000 and 1,648,000 from the monies in court. And then in addition, they received 1.5 million from what's called the SCB monies. My lords, then there were various court applications here in England between the parties. Those are summarised in paragraphs 19 to 28 of the Statement of Facts and Issues, and the judgments in respect of those appear in the supplemental bundle. In effect, what was decided was that the deed of charge conferred only a floating charge, and that therefore, pursuant to that, Candey were only entitled to the value of services. Originally, His Honour Judge Rayside said that that was equivalent to the fixed fee agreement, which he determined was fair and reasonable, but the Court of Appeal said that that was wrong and remitted that to the High Court, and that came back before His Honour Judge Davis White, and he determined that the value of the services supplied was £1,090,755.
Do you have the page number for the floating charge judgment, the one that declared it was a floating charge?
I do. It's the decision. It's in the supplemental bundle.
Right.
Tab 10, page 144.
Thank you.
In that judgment, His Honour Judge Davis White also determined that that the monies in court and the SCB monies were monies that were caught by the floating charge and were not new monies, as contended by the liquidators, and that was appealed to the Court of Appeal, but the Court of Appeal dismissed that appeal. Well, my lords, as far as the lien, as far as the application that's found its way before your lordships, it was on the 29th of March 2018 that Candey asserted it was entitled to a lien pursuant to Section 73, and the letter is at Appendix 7 of the core bundle, tab 14, page 358, and it was on 17th of April 2018 that the lien application was issued. That application came before Mr. Hockhauser, Queen's Counsel, sitting as a deputy judge, and he dismissed the lien application, finding that Candey had waived the lien. The judgment is at tab 7 of the key documents bundle, page 155. He also dismissed the liquidators' arguments based on post-liquidation waiver, instrumentality, abuse of process, and discretion. Candey appealed that judgment, and the liquidators filed a respondent's notice in respect of post-liquidation waiver, abuse of process, and discretion. And on the 23rd of January 2020, the Court of Appeal dismissed the appeal. That's tab 5 of the key documents bundle, page 121. The Court of Appeal found that the fact that PHRL had taken independent legal advice made no difference. The intention to waive could be inferred because of the following inconsistencies. First of all, the deed of charge, whilst covering additional property, also covered the same property as that covered by the lien. Secondly, the deed of charge had a different priority. Thirdly, the fixed fee agreement and the deed of charge provided for interest to 8%. The Court of Appeal made no findings in relation to the further argument that the fact that the deed of charge conferred a right to appoint a receiver was a further inconsistency. But the Court of Appeal did find that Candey had not reserved the lien, but did not decide the question of post-liquidation waiver because of its findings on pre-liquidation waiver made it unnecessary. But they did go on to say that the deputy judge had been wrong to find against the liquidators on post-liquidation waiver for the reason he did. And we'll look at this in due course, but in effect, the deputy judge said there was no need to refer to the lien in the proof of debt because of the authorities such as Hames and Cooper to the effect that everybody seemed to know about the lien. The Court of Appeal said that's not right, but we're not going to go on to decide the rather difficult issue concerning the construction of Section 214 of the BVI Insolvency Act because we don't need to. The Court of Appeal also did not make any findings in relation to abuse of process and exercise of discretion, again because it didn't need to, although Lady Justice Rose said that her inclination would have been the same as the judge, namely that if the lien had not been waived, the court would not decline to grant the charging order on the basis of abuse of process or discretion. And then, my lords, on the 29th of March 2021, the Supreme Court, Lords Briggs and Leggett granted Candey permission to appeal. Now, my lords, why does it matter? In the sense that we've got our floating charge and we're entitled to just over £1 million in respect of that. It matters because it affects priority and also because of the quantum to which Candey are entitled to. as far as priority is concerned, it's common ground that any rights under the lien are akin to salvage, so that they will rank first, ahead of even a first legal charge. As to quantum, Candey's entitlement under the lien to its assessed costs. Now, my lords, if we succeed on this appeal, it will be a matter for another day as to whether or not there needs to be an assessment because of the fixed fee agreement, and whether or not we are entitled simply to the sums provided for in the fixed fee agreement. Even if we're not entitled to the fixed fee agreement, the exercise on any assessment of costs will be a different exercise to that carried out by His Honour Judge Davis White, and in our submission will result in us getting more than we've been found to be entitled to under the floating charge.
On your point about priority, my understanding was that the litigation funders' alleged priority has gone by the board because the liquidators have established that there's no claim by the liquidation.
That's right.
Litigation funders. So the real priority issue, as I understand it, is between your clients and the liquidators' expenses.
I suspect that's right.
It can't just be a matter of suspicion.
No.
Petitioning creditors' costs as well.
Yes.
It's not simply the liquidate and then disbursements as well.
Yes.
It's not simply that. But yes,
Yes,
you're right that the Campion Maverick charge has gone because we found it wasn't a proper charge. It wasn't a proper expenses.
My lord, we wrote to the liquidators' solicitors saying, where are we? What's the current state of play? How much is in the pot for everybody? And they replied on the 22nd of February this year, and that's in the supplemental bundle, tab 2, page 4. And at page 9, they explain...
By which bundle are we in now?
The supplemental bundle.
Yes.
It's a bit confusing for us because we've got a couple of supplemental bundles. I don't have this at page 4 of either of them.
This is Stevens and Harwood of 22nd of February.
Yes.
I have what's called a supplemental bundle and then a supplemental key documents bundle, which is the one that contains the FFA.
That's right. That's the 3-page one, but I'm referring to the larger document. And at page 9 of that, they confirm that the outstanding balance to Candey, after taking into account what's been, because some sums have been paid already, under the fixed fee agreement is £3,037,391.73, with interest of £1,501,288.65. The outstanding balance to Candey pursuant to the floating charge and the judgments as to the value of services is £267,509.27, plus interest of £111,987.54. They confirm that if Candey is successful on this appeal and successful in arguing that its entitlement is to the full fixed fee plus interest, there will be insufficient funds for the unsecured creditors. But if Candey is unsuccessful, there is sufficient to pay at the sums due under the floating charge and a small dividend for unsecured creditors.
Could you just explain, in a sentence or two, why it was that your clients waited until the 29th of March 2019 to raise the lien?
2018.
2018.
I can't. It may be, as speculated, I think, by the liquidators, that they hadn't thought about it. But I mean, the simple fact is, and this is at the nub, I think, of my learned friend's abuse of process argument, is it was not raised until the 29th of March 2018.
So you accept the inference that they had just not thought about it?
I think that's a perfectly fair inference.
Yeah.
I'm not sure it matters. I mean, what does matter, for the purposes of my learned friend's abuse argument, is the simple fact that it wasn't raised until then. But of course, and I'll develop this in due course after lunch, in our submission it wouldn't have made any difference, because we would have still had this argument. The only circumstance in which we not had this argument is if we'd succeeded before His Honour Judge Davis White, when the matter was first before him, in establishing that it was a fixed charge. So if we'd won that application, we wouldn't be here today. But having lost that argument, then the lien did become relevant. So, my lords, with that introduction, can I take you, hopefully relatively quickly, to the relevant authorities? In my submission, this is probably the best way of dealing with it, rather than keep on going back to the authorities, is if I take you through in chronological order. And please tell me if I'm going too quickly. First of all, section 73 itself is in the authorities bundle at page 778. It's tab 29, page 778. And it provides, subject to subsection 2, any court in which a solicitor has been employed to prosecute or defend any suit, matter or proceedings may, at any time, declare the solicitor entitled to a charge on any property recovered or preserved through his instrumentality for his assessed costs in relation to that suit, matter or proceeding, and make such orders for the assessment of those costs and for raising money to pay or paying them out of the property recovered or preserved as the court thinks fit. Now, my lords, as far as the authorities are concerned, the first authority I want to take your lordships to is retailer. That's in tab 26 at page 723. Just reading the head note. The firm of solicitors received for some years on behalf of the lady the income payable to her under the terms of a will, and from time to time made advances to her and payments on her account. On being applied to for delivery up of her papers, they sent in an account of their receipts and payments showing a balance of £81 due to them and claimed a lien for that sum. The only item in the account of such a nature that the taxing master could have moderated it was our cost to date £20. She applied for an order for delivery up of her papers on payment of £20. Mr. Justice Sterling refused the application, holding that the £81 ought to be paid into court.
This is a common law possessory lien.
It is, my lord, and that's a very important point, because most of these cases are concerned with possessory liens. And I'll develop why that matters once we've been through the authorities.
Well, it certainly helped me as we go through. If you could just
highlight.
Tell us the principle that you're going to be relying upon before we move on to the next.
As we'll see, the bulk of the cases are concerned with a possessory lien. In my submission, it is not a huge step where a solicitor is saying, I've got these documents, I'm entitled to hold on to them, to say you're not, because you've entered into a new arrangement. You've taken a new security, for example, that says payment doesn't have to be made for 3 years. In those circumstances, one can see why it's easy to infer an intention to waive, because you can't, as a solicitor, say to somebody, you don't have to pay me for 3 years, and then say, in the other breath, that during those 3 years, I'm still entitled to hold on to the papers. But there is no analysis in the authorities, which are largely concerned with possessory lien, as to why one can simply take the principle or find a principle in the possessory lien cases and apply it to the equitable lien. Held by the Court of Appeal that there was no lien for anything more than so much of the £20 as should be allowed on taxation.
Is that the ratio? Is that the ratio? The they decided the case on the basis that she had offered £20 and
there was
and that was sufficient.
Yes,
And
but reading on, my lord,
yes.
You'll see then that after the decision of Mr. Justice Sterling, the new solicitors of the lady discovered that she and her husband had given to the solicitors a joint and several promissory note, payable on demand and bearing interest at £5% as security for what was due to her, and held. One has to be careful here because this is wrong. This is not what they found, but held that whether the taking of security by a person having a lien is an abandonment of the lien depends on the intention, whether expressed or to be gathered from the circumstances of the case. That's right. That prima facie, where a solicitor whose duty is to advise his client as to his rights and liabilities takes from his client a security for costs without explaining that he intends to reserve his lien, the lien is abandoned and that such was the result in the present case. That is wrong, and that's commented upon by the Court of Appeal in Re Morris.
Do you mean it's wrong in the sense it's been subsequently overruled, or just a wrong head note?
It's a wrong head note.
Right.
Because in fact, what the Court of Appeal said is one has to infer an intention to waive, and you can do that if there are the relevant or necessary inconsistencies between the new security and in this case the possessory lien. Now, my lords, as far as the judgments are concerned, the judgment of Lord Justice Linley begins at page 729 in the bundle. Five lines down, the case raises serious questions. First of all, we have to consider for what a solicitor is entitled to a lien on his client's documents. And that, they decide, is the £20. But then over the page 730, 5 lines down, there was another important point raised by Mr. Cousins-Hardy. He contends that whatever lien the solicitor has was waived by his having taken a security. The security in this case being a promissory note for £200 given by the solicitor's client, who was a married woman, and by her husband, and bearing interest at 5%, and also a charge upon a certain policy. Mr. Cousins-Hardy urges that taking that security was a waiver of the lien which the solicitor would otherwise have, and in support of that contention he relies mainly upon the case of Robertson Jeffrey. In considering this point, we must be careful. Whether a lien is waived or not by taking a security depends upon the intention expressed or to be inferred from the position of the parties and all the circumstances of the case. In this particular instance, we are dealing with a solicitor and his client. It strikes me that if a solicitor takes from his client such a security as this solicitor took, the prima facie inference is that he waives his lien. That appears to be the right and proper conclusion to come to, bearing in mind that it is the solicitor's duty to explain to his client the effect of what he is about to do. In the case of a banker, I should not draw the same inference, since a banker has not a similar duty towards his customer. Bearing in mind the position of the parties and having regard to the decision of Sir John Leach in Roberts v. Jeffrey, we are justified in saying that in the absence of evidence to the contrary, the true inference from the circumstances is that the lien was waived. And, my lords, the important point, and we'll see in later judgments, the words such a security as this solicitor took are emphasised. Because in my submission, what Lord Justice Linley is saying, and we see this developed in the later authorities, is in effect there's a two-stage test. The Court of Appeal, in our case, refer to this, and I think accept this two-stage test. First of all, can you infer an intention to waive? And the answer is you can. It depends upon all the circumstances, but you can if there are relevant inconsistencies between, in this case, the possessory lien, and on the other hand, the new security. Then there is a second stage to the test, which is that prima facie, therefore there's been a waiver. Did the solicitor reserve, expressly or impliedly, his lien? And my lords, so you know what our position is, we're seeing the authorities, you can see here, reference to solicitors being in a different position to bankers, innkeepers and whatever. In our submission, that difference on the authorities is only relevant to the second question, to the question of reservation. Because it is at that stage that the duty of disclosure might be relevant. So that the first stage, is there an intention to waive? We both accept that is an objective exercise. But what it isn't is a spot the difference exercise. It isn't a question of holding up what the solicitor has, either under his possessory lien or his equitable lien, and comparing it with what he has under the new security. Because it's not any difference that would enable an inference of an intention to waive. My lords,
what do you say was the inconsistency in retailer?
In retailer, and is the provision in the promissory note for interest at 5%. That's the same as in Roberts and Jeffrey, which is the case they refer to. And indeed, in the authorities, that is the most common difference. My lords, judgment of Lord Justice Lopez, page 731, halfway down the page, having dealt with what's covered by the lien. Another point is raised by the appellant that the solicitors have lost their lien by taking security. It appears to me that in each case, the question whether the lien is waived by taking security must be decided according to the particular circumstances. I do not mean to say that taking a security necessarily imports an abandonment of the lien. But if there are circumstances in the taking of the security which are inconsistent with the continuance of the old security, it is to be inferred that the solicitor intended to abandon his lien. In the present case, the security given is a promissory note, payable on demand with interest at 5%, under which the amount could be recovered at once. There is also a charge upon a policy. The promissory note is not given by the wife alone, but the husband joins as surety. Under these circumstances, it is only a fair inference to draw that there was an intention between the parties to give up the old security of the lien and to rely on the security I've mentioned. I may add that we are deciding the point in accordance with the decision of Sir John Leach in Roberts and Jeffrey. And then Lord Justice Kay, page 732, at the bottom of the page, as regards the second point, the subject of the loss of lien by taking security was well considered in Cowell v. Simpson. Lord Eldon there, after referring to a lien on goods, says the exigencies of mankind requiring the goods to be delivered for consumption, the implication from an engagement for the security of an engagement to deliver the goods without payment is necessary. Otherwise, from a promissory note payable in 3 years, a contract must be implied that the goods are to be retained during that period, destroying the other special contract. So in this instance, if the solicitor says he will not proceed in the business and will not deliver up the papers, the consequence is that he destroys the express contract to postpone payment for 3 years. Therefore, unless from the fact that he has taken this security you can imply that he is to keep the papers 3 years, though the vital interests of the owner may depend on the possession of them, the implication is necessary that he is to deliver them up and rely on the other contract. Lord Eldon there relied on the fact that the promissory note was not payable for 3 years. Then refers to Stevenson and Blakelock. And then about 12 lines from the bottom, in Borch v. Symes, Lord Eldon said, notwithstanding the Court of King's Bench has expressed a doubt whether my decision was right in Cowell and Simpson, I still entertain the opinion that an attorney who takes a security abandons his lien. This has been construed as laying down that a solicitor taking a security for his costs always abandons his lien. But Lord Eldon does not say that. He only said that he abode by his former judgment. I take it that the true rule is that stated by Lord Justice Linley, And in every case where you have to consider that whether a lien has been waived, you must weigh up all the circumstances of that particular case. And it is an important consideration that we are here dealing with a transaction between a solicitor and his own client. A solicitor has a duty to perform towards his client, to represent to his client all the facts of the case in a clear and intelligible manner, and to inform him of his rights and liabilities. And where you find a solicitor dealing with his client and taking from him such a security as was given in this case, not expressly reserving his right of lien, I quite agree that the inference ought to be against the continuance of the lien. So, my lords, that's retailer.
It's maybe worth noting that Lord Justice Kay also had in contemplation equitable liens. He refers to that at 732, I think it is. About halfway down, when he refers to Plumer.
Yes.
There are two kinds of lien, one on the funds recovered, the other on the papers. So the former one will be the type that we're concerned with.
That's absolutely right, my lord. My lord, the next case chronologically is Groom and Cheesewright. That's at tab 16, page 597 of the authorities bundle. And just reading from the facts, Mr. Edmund Kimber had acted as solicitor for the plaintiff in this action, the object of which was to recover from the defendants, Cheesewright and Patterson, shares and monies alleged to be due from them to him. During the progress of the action, a mortgage was at the request and by the advice of Mr. Kimber executed by the plaintiff for the purposes of securing his costs. The mortgage, which was prepared by Mr. Kimber, dated 25th of May, between the plaintiff and Mr. McCall, after reciting that the plaintiff was entitled to have transferred to him by certain persons 100 fully paid up preference shares of £5 each, that the plaintiff was indebted to Kimber for certain cost charges and expenses in connection with the Chancery suit, and otherwise was desirous of securing the same and also any future cost charges and expenses. Also that the plaintiff was indebted to several persons mentioned in the schedule, and also that the plaintiff was now claiming in another action a large sum in cash and shares. It was witnessed that the plaintiff thereby assigned to the said McCall the said 100 fully paid up preference shares in the said company, and also the cash and shares coming from Cheesewright and Patterson, upon trust, in the first place to secure to the said Kimber the payment of any cost charges and expenses which may now at any time be due in relation to the Chancery suit. Action proved successful, and Mr. Kimber received on the plaintiff's behalf 185 fully paid ordinary shares of £5 each and 50 preference shares. Mr. Kimber now moved for an order for a charge upon the shares in the Fifeshire Mail and Collieries, at present remaining unsolved, which were recovered in this action, and all other property so recovered, and for an order that such costs should be raised pro tanto by a sale. And then the judgment of Mr. Justice Kekewich.
No, it's sort of possessory and equitable, Lien.
Yes, it appears to be.
In the sense that he had possession of the shares,
He
which
had
were
the shares.
Fruits of the litigation. Yeah.
But yes, but your lordship's right, but he's also applying for a charge. And in the judgment of Mr. Justice Kekewich, about 10 lines down, I have before me this neat point, a point which is not covered by decision. The plaintiff, Mr. Groom, got Mr. Kimber to accept during the progress of the action a charge for his costs upon the property to be recovered in the action. Of course, Mr. Kimber was entitled to accept the charge, but he, at this time being Mr. Groom's solicitor, then the plaintiff, Mr. Groom, assigned to a trustee not only whatever property might be recovered in this action, but also some other property, which was the property in the second action. And then 5 lines down, under that trust deed, the trustee would be entitled to retain out of the property assigned his costs, charges and expenses as trustee. But subject to that, Mr. Kimber accepted a first charge upon this property, and now he asks to have a charging order upon the same property, the only advantage of which would be to give him a footing above the deed which he has accepted as a security in 1893. That is, he now says, before the trustee can get his costs of recovering the property out of which he is to pay my charges, these charges must be paid. Consider the intention of the legislature under this Act. The intention is to give the solicitor an ancillary right. It is not intended, and I think the cases all bear me out in this, to displace the liability of the client to pay the solicitor out of his own pocket, and it has been doubted whether a charging order ought to be made at all where the client is a responsible person. At any rate, it was not intended that the right of a solicitor to a charging order should be absolute. On the general principle that for a solicitor to accept security for his costs is inconsistent with his right to payment otherwise, it seems to me that Mr. Kimber has put it out of his power to get the order he now asks. I have pointed out that that would be the inconsistency of it, and in my opinion that inconsistency is fatal to his application. Now, my lords, in our submission, Mr. Justice Kekewich, he's plainly reached the right decision, because what the solicitor was doing, having entered into the charge, allowed for the appointment of a trustee, whereby the trustee was going to get his costs paid, he's now seeking to jump ahead and be paid ahead of the trustee. But what we do take issue with, and Mr. Justice Nugee does indeed in one of the later cases we'll look at, is the general principle that Mr. Justice Kekewich is setting out. It is
quite
not
a strong similarity with this case, isn't there? I mean, you get a floating charge, which prima facie would give you recoveries subject to liquidators' expenses if they'd realised the property subject to the charge. But you say, oh no, you've got a prior equity and that beats their expenses.
I accept that, my lord, but what we're looking at is the intention of the parties. And the clear intention was that we would get a fixed first charge. That's what we intended to get.
What, under the floating charge?
Yeah, but this was the argument that took place.
Well, it's a funny kind of intention. Wasn't it a decision on the construction of the charge?
Yes. And
so the objective intention to which Mr. Davis White extracted from the charge was that it was a floating charge.
Yes, right, my lord. But at the time, one looks at the documents here and say, can you infer from this an intention to waive the Section 73 lien? And the point your lordship's raising, I think, is the second point, the second inconsistency, if I can put it like that the Court of Appeal found, which was the question of priority. And that depends largely on what we call Clause 5 of the deed of charge, whereby it's acknowledged that we will be paid first, subject to any bona fide liabilities to Campion Maverick.
Well, Mr. Lord, I don't want to take you out of your course.
I mean, I will address the point.
Put a marker, at least put a marker down.
Yes.
That to come back after losing on the floating charge argument and say, yes, but it was really intended to be a fixed charge, at any rate, causes me a bit of a raising of eyebrows.
I understand the point, my lord. I will deal with it at the appropriate moment. But my lords, the only point I'm making in relation to Groom and Cheesewright is that the general principle that Mr. Justice Kekewich sets out is too wide, because he appears to be saying that accepting any other security for your costs will give rise to an inconsistency and therefore a waiver. And that is not what the Court of Appeal was saying in Retailer, and it is not what, and we'll see, it's not what's said in the later authorities, and Mr. Justice Nugee expressly refers to this in the Solon No. 2 case, and in effect says that Mr. Justice Kekewich is wrong. That's too wide. My lords, the next case is Re Morris, and that's tab 20, page 623. in the head note, where a solicitor takes any security for its general costs, which is inconsistent with the retention of his general lien, since it gives him some special advantage which the enforcement of the payment of his costs by the exercise of his right of lien would not give, that lien is gone unless he gives the client express notice of his intention to retain the lien. And then Lord Justice Kennedy, if a solicitor, when taking from his client any security for general costs, intends to retain his lien, he ought either by express words or by necessary implication to make that intention known to his client. So, my Lord, you have the majority, Lord Justices Alveston and Buckley, saying that it has to be an inconsistent further security from which you can infer the intention. And you have in the minority Lord Justice Kennedy saying any other security will amount to a waiver. And, my Lords, reading 623, on 9th of November, 28th of May and 19th of June, Mr Weiler deposited with Messrs Ashurst Morris Crift certain securities. Letters accompanied said they were security for my account with you, as security for costs in the House of Lords Appeal, and as security for my account and for the costs in my libel action. It was contended by the firm as being the proper inference to be drawn, both from the whole correspondence and from their oral interviews as deposed to an affidavit, that the securities were not handed to the firm in respect of their general costs, but in respect of counsel fees and out-of-pocket expenses. And Mr Weiler, it was contended for that they were general costs. Mr Justice Bucknell decided that the securities so given were not given under such circumstances so as to destroy the solicitor's lien. So, in effect, there were two questions. What were the securities given in respect of? And secondly, was there any waiver? And the Chief Justice said, I have had the opportunity of reading the judgment prepared by Lord Justice Buckley, in which I entirely concur. Prima facie, a solicitor has a lien for his charges upon the papers of his client. So again, this is a case dealing with possessory lien. This lien may be lost, released or waived in the same way as the liens which other persons possess. The main difference between the case of a solicitor's lien and those other liens is that where a solicitor takes any security which is in any degree inconsistent with the retention of a lien, it is his duty to give express notice to the client if he intends to retain the lien, and that should he not do so, his lien will be taken to be abandoned. And then over the page 626, that's where he deals with what the other securities were security for, and he finds that they were security only for counsel's fees and for out-of-pocket disbursements, and not for general costs. And then towards the bottom of the page, about 10 lines from the bottom, it remains to consider only one further point raised on behalf of Mr Weiler, namely that in sending the security in a letter which contained the words of security for my account and for costs in the libel action, Mr Justice Bucknell also ought to have decided that the security was given and received on account of his general costs. That would not be right. And so, in effect, the Chief Justice is simply saying that the security didn't apply to the general costs, and therefore the possessory lien remained. Lord Justice Buckley, page 627, where a solicitor entitled to a lien takes from his client security upon property already included in the lien, or where such an one takes a security which gives time, say for a period of 3 years, or which gives a right to interest which would not otherwise be payable, it may be that the lien is gone. In such cases, there is a new arrangement between creditor and debtor which within Lord Watson's words in Bank of Africa against Salisbury, is incompatible with the retention of the lien. The existence of the security is inconsistent with the continued existence of the lien. I point out at the outset that the security in this case has not those characteristics. The question which arises in the present case is this general question. Is the solicitor's lien gone? In other words, has the solicitor waived or released his lien if he takes security for his costs or for part of them, without communication made to his client by which he expressly or having regard to all the facts impliedly reserves his lien? Or at any rate, is the lien under those circumstances prima facie gone, and is the onus on the solicitor to show that it is not gone? No doubt the case of a solicitor differs from that of other persons in respect of his right of lien, a difference which arises from the fact that it's the duty of the solicitor to explain to his client the effect of that which the client is about to do. But bearing this in mind, the law, as I understand it, does not answer affirmatively the general question which I have put. He then refers to Cowell and Simpson and Borch and Symes, and I think we can pick it up on 628, 8 lines from the bottom. Mr. Isaacs has relied strongly upon in re Taylor. The head note in that case is, I think, too large. It will be found that each of the Lord Justices relies not upon the fact that the solicitor had taken security from his client without explaining that he reserved the lien, but that he had taken such a security as the solicitor there took. Promissory note payable on demand with interest at 5%. It is true that in that case payment was not postponed, but there was created a right to interest which otherwise would not have been payable. I cannot find it laid down anywhere in the judgments that the mere fact that the lien was not expressly reserved concludes the matter. That point is not even referred to by Lord Justices Linley or Lopez, and is not made the ground of decision by Lord Justice Kay. The ground of decision is found in the words of Lord Justice Linley, which Lord Justice Kay adopts. Whether a lien is waived or not by the taking of security depends upon the intention expressed or to be inferred from the position of the parties and all the circumstances of the case. Then refers to Douglas Norman and then goes back to Reed Taylor after citing passages from that case in which both Lord Justice Linley and Kay had spoken of the solicitor taking such a security as in that case. And then he refers to Lord Esher, which we've looked at in the context of Reed Taylor, then to Lord Watson in Bank of Africa. My Lords, then you have the minority judgment of Lord Justice Kennedy. He in effect decided that the taking of any security would amount to a waiver. And you can see that from the paragraph beginning. I should have felt some difficulty in reaching this conclusion if it had been necessary to concur in the view that it is only in the case of his taking from the client a security for his general costs inconsistent or incompatible with the retention of his lien. So, my Lords, that's re Morris. My Lords, then, if we can look at Curry against Ray, which is a decision from Northern Ireland, it's behind tab 12 at page 532. This is again a possessory lien case. In an action for detenue of title deeds, the defendant pleaded a lien for costs and monies advanced, and alternatively a right to detain the documents as mortgagee. Plaintiff replied that the alleged debt and mortgage were barred by the statute of limitation. The trial judge held that there was a debt due to the defendant and that the defendant was entitled to hold the documents as lien. He did not consider any question relative to the mortgage, as he was of the opinion that no mortgage had been proved or handed in, and he refused at the close of the case to allow it to be included. Plaintiff appealed, seeking to have the judgment of the trial judge set aside on the ground, amongst others, that the trial judge failed to give proper consideration to the argument that the lien had become merged in the mortgage. So there were, in effect, two questions. The first was whether or not there was a mortgage, and secondly, whether or not by taking out the mortgage, there had been a waiver of the lien. And it was held that the mortgage must be taken to have been sufficiently proved, held that the court was entitled to consider the issue of waiver, held that when the defendant took his mortgage, not having made known any intention to retain the security of his lien, he must be regarded as having waived such lien, and nothing had appeared which could have the legal effect of reviving it. And then the final holding that the plaintiff was entitled to succeed and that an order for delivery up of the title deeds to him should be made.
It's a possessory lien case.
It's a possessory lien case again, yes, my Lord. And then in the judgments of the Court of Appeal, Lord Justice Andrews identifies the issues along the lines I hope I just did, bottom of page 541. Was the mortgage properly in evidence? And if so, should the issue of waiver of the lien be considered by us, having regard to the pleadings? And then the bottom of 542 8 lines from the bottom, in these conflicting circumstances, but not without considerable misgivings, I've come to the conclusion that the mortgage must be taken to have been sufficiently proved. I now pass to the second question. Should the merger issue be entertained by us? And she enters, just after halfway down, a strong personal protest against the growth of this process of raising it and it's not being properly raised on the pleadings. And then goes on, assuming, however, the issue to be open to the plaintiff, I proceed to consider the proposition for which the Attorney General contended that when the matter was first argued before us. This was that when the defendant took his mortgage, he waived his possessory lien, which in law became merged in the mortgage, and that both the defendant's mortgage debt and his interest in the land comprising the mortgage have been extinguished. Now, my lords, this is, I think, the only case where there is a security taken on the same property. So, solicitor is holding the title deeds to the property, seeking to exercise his possessory lien over that property, but, as the Court of Appeal have now found, has been granted a mortgage over that property. And then, picking it up again, Lord Justice Andrews, 543, 8 lines from the bottom, there are two limbs to this argument. As to the first, the leading case is Retailer. And then he cites from Retailer. 544, he considers Douglas Norman. And then says, now in the present case, there is no evidence to show that either by express words or necessary implication did the defendant, when taking the mortgage, make known to his client his intention to retain the security, and that such lien must, in my opinion, be regarded as having been absolutely waived or abandoned. So, my lords, what one doesn't have in this judgment is any analysis as to what the inconsistency is and why it gives rise to an inference of an intention to waive. What you do get in that paragraph is a finding, in effect, that there was no reservation.
Well, he's reading, I think, the judge, I think, is reading Lord Justice Kay in particular as meaning that that it would be a breach of fiduciary duty for the solicitor to take a fresh security from a client without disclosure of the lien, and therefore, if the lien is not disclosed or expressly reserved, it follows that the new is to be taken as having been waived, because otherwise the solicitor would be in breach of his fiduciary duty.
Well, your Lordship may be right, but that's not what the Court of Appeal said in Re Morris, and indeed it's not what the Court of Appeal said in Retailer, because what one gets from those judgments is a clear two-stage test.
Well, it's a rather confusing test, to be honest, at the moment, because I mean, if it's an inconsistency, then one would have thought it follows there must be an implicit waiver. And what does the special duty of a solicitor have to do with it?
I respectfully agree, my lord, and I'll come on to that. I think if I just go through the authorities and then try and distill from them what the principles are. But my observation at this stage is that what's clear from the two Court of Appeal judgments is this two-stage test. First of all, is there an intention to waive? And you can find that or infer it as a result of an inconsistency. So that if you have a possessory lien and give somebody 3 years to pay, it would be inconsistent with that. And you have a security for that, a promissory note or whatever. It would be inconsistent with that security to then seek to rely upon your possessory lien. The other feature that looms large in these older authorities is the question of interest. If you don't have any right to interest, but you get a promissory note by way of security that provides for interest, then one can see, particularly in the case of a possessory lien, that you can infer from that that you're no longer relying upon your right to hold on to the title deeds. you're relying upon your new security, your promissory note, with interest. But then there's a second question. And in our submission, any duty, fiduciary or otherwise, but any duty of disclosure could only ever be relevant at the second stage, because the first stage, my learned friend and I agree, is an objective exercise. It's a question of looking at what the solicitor has, either under his possessory lien or under his equitable lien, and looking at the further security to see if there's something in the further security from which you can infer an intention to waive, either the possessory lien or, in our case, the equitable lien. Then, having done that objective exercise, if you find that you can infer that intention, you go on to the second question. And it is only in relation to that second question that the duty of disclosure could ever become relevant. And it may
I just
be...
have difficulty, I'm sorry for interrupting, in understanding the second question at all, because the first question is whether there is a sufficient inconsistency to imply waiver.
Yes.
Well, whether a person is a solicitor or not a solicitor, then you can resolve, you can say, well, there are inconsistencies, you could imply waiver, but the second question is then, have you expressly retained?
Or impliedly.
Well, I just wonder about that. But everybody can expressly retain, so whether you're a solicitor or not doesn't make any difference.
No.
Okay? And anybody, on your analysis, can impliedly retain. I have difficulty about the impliedly retain because it seems to come in twice, once under the first limb and secondly under the second limb. But I don't see why it is that the solicitor's status or relationship has got anything to do with these tests that you're putting forward.
My Lord, we respectfully agree. But there is no doubt, you've already seen it in the judgments of the Court of Appeal in both Retailer and Remorse, that their lordships do seem to say, they do say, that the position of a solicitor is somewhat different from that of a banker or innkeeper. But there is no explanation in any of the authorities as to why.
Well, I thought, look, I was taking from what Lord Justice Case said in particular, that it's to do with the explanation is the solicitor's fiduciary duty to his client. And if the retention of the lien would amount to a breach of his fiduciary duty because he had failed to disclose, to make full disclosure to his client, then the equitable principle you deem somebody to have done what he ought to have done would lead you to the conclusion that he's waived the lien.
Well, I understand that, my Lord, but the first stage of the test is an objective exercise. So it is an exercise of looking at either the possessory lien or the equitable lien, and then looking at the new security and seeing if it's clear it's not any new security. It must be a security that is inconsistent with the retention of either the possessory lien or the equitable lien.
Yeah. Well, now, if it is, I don't really see how reservation comes into it.
No, my Lord. It is only if, having done that objective exercise, to which, in my submission, whether or not you're a solicitor, a banker, or an innkeeper, doesn't make any difference whatsoever. But having done that exercise, and having found, for example, that there is a right to interest under the new security, which did not exist under the retainer, so that you can infer that intention, you then come on to the second question, which is a potential get-out for the solicitor, if he has expressly, or we would submit impliedly, reserved his lien. Now, for our part, even at that stage, it is at that stage that one could see the potential for the duty of disclosure to come in. But why? What is it that the solicitor should disclose? It can't be the existence of the equitable right or the Section 73 lien. because everybody's deemed to know about it. It cannot be the existence of the terms of the new security because the client has just signed up to it. It cannot be the solicitor's intention because that's to be determined objectively. So it could only be that he is to disclose that he is in fact retaining or preserving his equitable Section 73 lien. But that is the exercise on the second stage. That is the simple question of reservation. Has he reserved the lien? If he has, if he's clearly stated that notwithstanding this new security, notwithstanding this promissory note giving me interest at whatever %, I still have my rights under Section 73, then he will be not deemed to have waived because plainly he hasn't. But your lordships have alighted upon one of the difficulties we have with these authorities, which is there is the reference to solicitors being treated differently. But why? And what difference does it make? Can't make a difference at the first stage because that's objective. But what difference could it make at the second stage? Because it is simply a factual question. Whether or not it's an innkeeper, a banker or a solicitor, has that person reserved the right? Doesn't make any difference whether or not that person is a solicitor or a banker. It's just a factual question. Whereas my learned friends take quite a lot of time in their case talking about the duty of disclosure. But where does it take them? It is a simple factual... There are two factual questions. Intention to waive, and therefore at that stage you're looking at inconsistencies and you're doing an objective exercise. Second question, was it reserved?
And so you...
Is it... Sorry, I'm so sorry. Well, I was going to ask, is a possible explanation of the conundrum which you're seeking to illustrate that the reservation, if there is an inconsistency,
yes,
such that that is prima facie evidence, if you like, I'm not sure the prima facie evidence really works in the context of an objective ascertainment of intention, but which is on the face of it consistent with an intention to waive the lien, then nothing short of an express reservation by the solicitor will do, and it rules out an implied reservation, because what the solicitor has to do is to explain to the client. Now, explanations of that kind are not easily achieved impliedly. Well, I notice you said, actually, reservation can be express or implied, but I'm just wondering whether it can be implied where it's a solicitor and client. Well,
the Court of Appeal say that it can be implied, both in Retailer and in Re Morris. It's in Retailer, Lord Justice Linley, at page 730 of the bundle. Re Morris, Lord Justice Buckley, at page 627 of the bundle.
Well, not the Chief Justice.
Yes.
But not the Chief Justice in that case. He didn't go that far.
No, he just doesn't. He doesn't really touch upon reservation, actually, apart from flagging
I'm sorry, where does Lord Justice Linley say it can be done impliedly?
What he says is it depends upon the intention expressed or to be inferred.
Well, that's the first stage.
Yeah.
But the second stage is if a prima facie inference of waiver arises, then if it's a solicitor-client relationship, that can only be dispelled, if you like, the burden shifts to the solicitor to show that he's expressly reserved it.
I see. Yes, my lord.
And that's what I'm putting to you as a possible explanation. You say, oh, no, Lord Justice Linley is talking about impliedly as well. But he's not talking impliedly at the reservation stage, I don't think.
Well, my lord, then we should also look at Lord Justice Buckley.
Yes, well, I was going to go...
It's 627.
Yeah.
And it's the middle of the page.
627.
And he is talking there, Lord Justice Buckley plainly is talking about reservation, or impliedly reserves his lien.
Well, or at any rate, is the lien under those circumstances prima facie gone, and is the onus on the solicitor to show that it is not gone? And yes, I agree, he does say or impliedly. But I'm not sure that he gets that from Reed Taylor.
But I understand the point Lord Briggs is making to me, which is a way of trying to distill from what the Court of Appeal is saying in these two cases a reason for solicitors being treated differently.
Well, no, I have no difficulty seeing that.
But why does it matter? Is the point I asked
Well, I can see why it matters. I mean, if the solicitor has acted in breach of his fiduciary duty to his client, then I can see why equity might prevent him from then asserting the lien against it.
But my Lord, there can be no suggestion that a solicitor has a fiduciary duty to tell his client about his equitable rights pursuant to Section 73. Otherwise, that duty would arise the moment a client retains a solicitor for litigation. The solicitor would be under a fiduciary duty to say, you should be aware.
Well, the point at which the fiduciary duty, the point at which the cases have focused on the existence of a fiduciary duty has been when the solicitor is entering into a transaction with his client for security. And unsurprisingly, one might think, there's been an insistence that the solicitor disclose to the client pre-existing security that he has by operation of law.
Well, my Lords, but there is no suggestion in the authorities of this fiduciary duty. The test of the authorities is, as I keep on saying, this two-stage test. And unless you can infer the intention, you don't get onto the question of reservation. When you get onto the question of reservation, it is not expressed as some kind of fiduciary duty. It is just a question. It's a question of fact. Did this person, be he solicitor, innkeeper or banker, reserve his rights?
I'm wondering, Rafa, what that means. If, looking at Lord Justice Buckley in front of us, he's contemplating in the first paragraph of his judgment a situation where, as he says, the existence of the security is inconsistent with the continued existence of the lien. Well, if that's the case, what difference do the words, I reserve my lien, make? Does it mean, I mean, you can't have both securities?
No, I think if the new security is inconsistent with the retention of the lien, but the solicitor says, let's say expressly for present purposes, but expressly says, I reserve my lien, then there is no waiver. On basic waiver principles, how can there be?
That's because inconsistency is a lower threshold, isn't it, than repugnancy. In other words, the lien and the security maybe have inconsistencies, but that doesn't, as a matter of law, prevent them both existing as securities.
That's right, my Lord.
It's just evidence of an intention to waive the first one.
Yes. Yes, and if you can see an intention from an express reservation that there was no intention to waive, then that trumps it.
Yeah.
To the extent of inconsistency, I mean, if by inconsistency you're meaning that the two cannot coexist, then by definition they can't coexist to the extent of the inconsistency.
That's what I would call repugnancy.
Right.
It seems, as I understand it, they can coexist.
They can.
But prima facie, there isn't to be assumed an intention that they should coexist.
That's right, my lord, because...
Unless there has been reservation, and then the reservation will enable them to coexist despite the inconsistency.
Yes.
I mean, by inconsistency, I think this must be a matter of English legal terminology.
Yes.
By inconsistency, do you simply mean a difference?
Well, as I stressed at the beginning, this is not a spot the difference exercise. It's a question of inferring an intention. But if you have an inconsistency with a possessory lien, such as you've got 3 years to pay, then one can see that the two can coexist, but it'd be very difficult, because how can you say, I'm still not handing back the title deeds to you, despite the fact I've said you don't have to pay me for 3 years? In the case of interest, it's somewhat different, because if I have a right to interest, that right could arise under a promissory note, and my right under my lien doesn't include such a right. Those can coexist. There's no problem with them coexisting. And in our case, there's no problem with them coexisting.
Okay, so I think the shades of the mist may be rising.
My lord,
so what Lord Buckley is really saying is that inconsistencies, in the sense in which the term is being used, are really a pointer towards waiver, but not necessarily conclusive.
yes.
Right. Okay.
My
So in
lord,
that context, one can see how at stage 2, if the failure to make if a failure to disclose a lien's existence, which is what would be involved in an express reservation, would be a breach of fiduciary duty, then you don't infer a reservation.
well, my lords, in my submission, the question of reservation is a factual question. Was it reserved or was it not?
Well, the judgments we've looked at all seem to think that the fact that the person in question is a solicitor is important here. Lord Justice Kay gives the clearest explanation of why.
Yes, and that, I think, is the point that Lord Briggs was alluding to, which I have some sympathy with, which, to the effect that if a solicitor is different from an innkeeper, you might say that he's under slightly more stringent duty when it comes to reservation. So that Lord Stevens's point about, well, I'm not so sure you can imply a reservation, you might more readily imply a reservation in relation to an innkeeper than you would to a solicitor. But my point is, it's only at that stage that one could see any basis for a distinction between a solicitor and anybody else. My lords, I'm looking at the time. I am actually slightly concerned about the progress we're making, but I'm going to struggle to get everything done by 3 o'clock, but I think that the transcribers deserve a short break.
Yes, certainly. We'll break for 5 minutes.
My lords, we were looking at Curry and Ray. We'd looked at the judgment of Lord Justice Andrews. Lord Justice Best, I think we just need to look at a short passage on page 550. 6 lines from the top. Whether the taking of security by a person having a lien is an abandonment of the lien depends on the intention, whether expressed or to be gathered from the circumstances of the case. The prima facie where a solicitor whose duty it is to advise his clients as to his rights and liabilities takes from his client a security for costs without explaining that he intends to reserve his lien, the lien is abandoned. Now, my lords, again, there's no analysis there. There's no analysis as to what the inconsistency is from which you can infer the intention. And there's no analysis as to what the solicitor should have advised his client, other than that he intends to reserve the lien.
Yeah.
He's not talking, I think, about an inconsistency here.
No, he isn't.
He's saying that you infer it because there's otherwise a breach of fiduciary duty.
Yeah, this is more aligned with the minority decision in Morris,
yes.
which is not English law, which is that the taking of any security will amount to a waiver unless you reserve. But that's not what the Court of Appeal are saying in Retailer or in Morris. So, my lords, there we are.
Which way does Mr. Justice McGaw go?
Sorry?
Which way does Mr. Justice McGaw go?
Well, he doesn't really deal with it at all.
Okay.
He says he only has a few words to add.
Maybe just see that. Which page is it?
It's page 551.
Thank you.
First of all, he says he has no doubt that the mortgage deed was entered into, which was the first question. And then he just goes on to the statute of limitations.
My lords, I think he deals with it in the last 4 or 5 lines of the first paragraph of his judgment, which is at page 551.
But on the execution of that mortgage,
yes.
It seems to me that had any lien on the deeds may have had came to an end.
I mean, that might be because that mortgage had an inconsistency, or it didn't.
Absolutely.
It just doesn't know. No.
This is Sir John McGaw's father.
Yes, yes, it was. We dealt with that in the Court of Appeal, and the Lord Justice Andrews was the brother of the chap that designed the Titanic and went down with it.
Ah.
And also Prime Minister as well. Another brother.
That's right. I don't think Lord Justice Best is any relation to either George or Rory, but we investigate that.
My lords, can we then go to Twig Farnell against Wildblood, which is in tab 27, page 735. Again, reading from the headnote, this is another possessory lien case. The defendant's solicitors acted for the plaintiff until 1991, at which time they retained in their possession the title deeds of a property belonging to him, over which they had a lien for unpaid fees. In 1994, they obtained judgment against the plaintiff in respect of those fees, and this being unsatisfied, they obtained a charging order against the property concerned. In 1996, the plaintiff successfully applied to have the lien set aside on the basis that the defendants had impliedly waived it when they obtained the charging order. The defendants appealed. The appeal should be allowed and the lien reinstated. Although a solicitor who obtained specific security for his costs while acting for a client was deemed in the absence of express words to have relinquished his lien over the client's effect, the principle had no application where at the relevant time the relationship between solicitor and client no longer existed. And then in the judgment of Lord Justice Mummery, if we turn to page 736, just below letter F, Mr. Brown identified 2 key issues. The first was whether the taking of the charging order amounted to the taking of a security inconsistent with the existing lien. He pointed to the fact that the plaintiff's solicitors in this case had not expressly retained the lien when seeking the charging order and therefore had waived the lien. There was also a dispute about the scope of the lien. It is important to mention at this point that the charging order related not to the cost but to the judgment debt. And of course, the judgment debt was in relation to the costs. Over page 737, section 73 set out, and then Mr. Brown accepted that that provision had not been invoked in this case. It was a procedure that could have been used, but it was not. It's unnecessary to say any more about it, because we're dealing with possessory lien. The thrust of Mr. Brown's main submission was that according to the case on existing solicitor and client relationships during which the solicitor took an alternative or additional security, there was a duty on the solicitor to inform the client that he was taking the security. If the solicitor did not do that, it would be inferred that he was waiving the lien by taking the alternative or additional security. He submitted, while accepting that there was no authority expressly on this point, that the same principle should apply as between a solicitor and an ex-client. Duty would be on the solicitor in connection with the ex-client to inform him that he intended to preserve the claim. On this point, he cited 2 authorities, Legate J and ABB, counsel for Holman's acknowledges that if the solicitor takes security for costs generally, and that security is inconsistent with his lien, and the solicitor does not in so doing reserve the lien, then prima facie would have been taken to abandon it. That's the two-stage test. His second case is more pertinent to the resolution, and that's Reed Taylor. The importance of that case is that it explains the principle underlying the general rule that where the solicitor-client relationship is still existing, the court may infer from all the circumstances of the case that the taking of the security by the solicitor who has a lien amounts to an abandonment. And then he cites from Lord Justice Lindley and Lord Justice Kay. Then says it's clear from those two passages to which Mr. Brown referred that there is a substantial and important difference between a case where a solicitor takes a security from a current client over whose property he has a lien for unpaid fees, and the case of a solicitor taking a security over the property of a former client. In this case, the solicitor-client relationship ceased. There followed contentious litigation about the claim by the solicitors for unpaid fees, resulting in a judgment for a debt. His Honour Judge Hild and District Judge Lippman came to the right conclusion when they said in this case there was no inconsistency between the taking of the charging order in respect of the debt and interest and the continuance of the lien for their debt and costs. There was no duty on the solicitors towards their former client to give him notice of their intention to take the security. They were taking that security in their capacity as judgment creditors. Now, Lord, that's important what Lord Justice Mummery is saying. He's saying, he's agreeing with His Honour Judge Hild and District Judge Lippman that there was no inconsistency. But, I point out, not to suggest there was an inconsistency, I agree. But there, the charging order was over the same property. It was in relation to a judgment that related to the costs. And then the short judgment of Lord Justice Shyman, the reason for the inference during the continuation of the solicitor-client relationship that the solicitor intended to waive his lien when taking further security is this. It is assumed that solicitors will intend to act in accordance with their duty. Their duty, if they are not waiving the lien, is to inform the client of what they are doing. If they do not inform the client, it is assumed in the absence of evidence to the contrary, that is because they are waiving the lien. For that reason, which is no different from that in substance expressed by my Lord, I would dismiss the appeal. Now, my Lord, with respect to Lord Justice Shyman, he's fallen into the same trap of the minority judgment in Morris. It is not the taking of any security, whether by a solicitor or anybody else, that amounts to a waiver. One has to do the two-stage test. It is not the law that whenever a solicitor takes an additional security, he has, in the absence of reservation, waived his lien. But what I rely upon this case for is the passage at the bottom of 738, where Lord Justice Mummery agrees with the judges below that there was no inconsistency anyway. So, my Lord, there's just two more cases, which are the two Solent cases, Clifford Harris against Solent International. There was a summary judgment application that was dismissed, and that was heard by Mr. Justice David Richards, as he then was, and then a further hearing before Mr. Christopher Nugent. The David Richards judgment is at tab 9, page 474. And I'm going to go through these pretty quickly. I just want to identify for your lordships the relevant passages. So in David Richards' judgment, 475, paragraph 3, he explains that the defendants were 4 of 7 defendants in proceedings in the Chancery Division. Paragraph 5, on the 31st of January, Mr. and Mrs. Solent executed in favour of Clifford Harris a legal charge over their freehold house in London, which was subject to a prior charge in favour of a bank. Putting it shortly, it secured the present and future costs and disbursements of the Chancery action and interest. I'll come back to the terms of that. Paragraph 6, on the 13th of July, Clifford Harris and Co. issued the Part 8 claim form. Paragraph 10, 477, the principal issue which arises is whether Clifford Harris had no reasonable prospect of success, so it should be summarily dismissed. And you can see in paragraph 11, the basis for that submission was that the grant of the legal charge constituted a waiver. Paragraph 13, he cites the principle that's set out in Cordry. If a solicitor takes security for costs generally, and that security is inconsistent with his lien, and the solicitor does not in doing so reserve the lien, then prima facie will be taken to have abandoned it. That's the two-stage test. Paragraph 14, Ms Harman took a prior point that the waiver principle applies only to a solicitor's possessory lien, and the judge didn't accept that. He says, paragraph 15, I can see no reason in principle why waiver should apply to a possessory lien but not to a right at common law or under section 73. My Lord, I'll come back to that, but in our submission it is difficult. It's far easier to see a waiver in the case of a possessory lien and a further security than the equitable lien. Paragraph 17, the issue which then arises is whether the taking of the legal charge had the effect of waiving the rights. Ms Harman submitted that inside this issue the court must consider all the circumstances of the case and the intention of parties, and in court should draw attention to passages in the authorities. In considering the security taken by a solicitor, the inquiry is not, in my judgment, as broadly based as Ms Harman suggests. What emerges from the authorities is that there are two key questions, as reflected in the passage cited from Cordry. Is the security inconsistent with the solicitor's rights at common law and under section 73? And, because of the fiduciary relationship between them, did the solicitor inform the client that he was reserving those legal rights? If it is inconsistent, it will be taken to waive the solicitor's other rights. So there the judge is acknowledging the two-stage test and then saying that it's at the second stage, namely the question of reservation, that the fiduciary duty element comes in and that solicitors might be treated differently. Now, I should just refer paragraph 18. He deals with the point that at the time of taking the legal charge, Mr. and Mrs. Solon received legal advice, and end of paragraph 18, 7 lines from the end. As for legal advice, the relevant facts are very much in dispute. However, even if Clifford Harris & Co. establishes its version of events, legal advice to Mr. and Mrs. Solon cannot take the place of information as to whether or not they intend to reserve. There is no evidence of any advice on this point. The central question is therefore whether the legal charge was inconsistent. Ms Harman submits it's over assets entirely unrelated to the settlement sum. Mr Marshall submits that in the context of a solicitor's rights, any security which gives the solicitor some advantage that he would not otherwise have, such as a right to interest or a charge on property, is inconsistent with the lien and amounts to a waiver, and he points to interest reserved under the legal charge. The judge then refers to retailer, and in paragraph 21 he sets out passages which we've looked at, but you see, my lord, he emphasises the words I emphasised when we were going through, such security as his solicitor took. And over the page, when he cites from, quotes Lord Justice Kay, such a security as was given in this case. He then refers to Robertson Jeffreys. The charge on the life policy in retailer was relevant only because it secured the principal and interest. The case is not authority for the proposition that the creation of a charge on an unrelated asset to secure costs and other amounts waives a lien. Then he says there is clear authority that a charge on the same asset as that covered by a lien or right to apply for a charge will displace the lien, and he refers to Curry and Ray. In my submission, that's not clear authority for that. What the judges, as I've just submitted, what the judges were doing was applying the wrong principle. He then refers to...
he says there's an obvious inconsistency between an express charge on the one hand and a lien or a right to apply to the court for a charge on the same asset.
He does. But he seems to get that from Curry and Ray.
I'm not sure. It seems to me he's expressing a view of his own, isn't he?
Well, if he is, and I'll address this when we come on to the relevant inconsistencies. I mean, we have two answers to that. One is our charge was not on the same property. It was a lot wider. And secondly, in our submission, in the case of the equitable lien, which I accept is what is being considered here. This is an equitable lien case, not a possessory lien case. But in the case of the equitable lien, there is no reason why a charge on the same property could not exist in parallel. And there's no reason for inferring an intention to waive from that. My Lords, he then deals with retailer and 25 re Morris. 26, he points out that in re Morris, they explained that the head note in retailer was wrong. 27, Mr. Marshall relied upon the minority judgment of Lord Justice Kennedy. And then he says, applying that test, Mr. Marshall submits that a charge on separate property, unconnected with the subject matter, gives the solicitor something beyond that which he would get through the exercise of his right of lien. I'm far from convinced that that's right. He then refers to Twig Farnell and says, in the context of the facts of the case, the reference to further security cannot, I think, be taken to mean more than security on the property for which the solicitor already holds the title deeds, i.e. the same property. I've not been referred to any case which either decides or in which the majority supports the view that the taking of a charge on an unrelated asset is inconsistent with a possessory lien or a solicitor's right to apply for a charge. In contrast, it's clearly established that if security is created which confers a right to interest, it will be taken to be inconsistent. He then deals with that and says it's far from clear that the right to interest, we'll see this in Mr. Nugent's judgment, the right to interest under the charge was 8%, but the right to interest under the retainer was 15%. And so Justice David Richards is there saying, well, I'm not sure that is giving them more under the charge. And then his conclusion in that respect is 34, page 485. The position is therefore, as presently appears, that legal charge should not confer any new right to interest and may indeed have reduced the applicable rate. It is at least seriously arguable that that is not the position on the facts of this case. And then Mr. Marshall further submits that the initial question is not whether interest was otherwise payable, but whether or not it could be secured by a charge under Section 73. He points to the terms of Section 73A, which provide for a charge for his tax costs, and to Lord Justice Kennedy's formulation that the legal charge is inconsistent if it gives the solicitor something beyond that which he would get by exercise of his right of lien. Mr. Marshall appears to be right that a charge under Section 73 does not secure interest. My Lord, we disagree with that, but I'll come on to that. But I think that Mr. Marshall is reading Lord Justice Kennedy's formulation out of context. The test, as referred to by Lord Justice Kennedy, as well as by the majority, is whether the security confers a right to interest which would not otherwise be payable. He therefore concludes that it's seriously arguable that the further charge was not inconsistent. My Lords, then, behind tab 10 is the judgment of Mr. Nugent, then sitting as a deputy judge, and he recites, it's page 490 it begins. Thank you. He recites the facts. Just point out 492, that there was a settlement agreement, 492 subparagraph 6, which said the Sheikh Mohammed parties and Solon parties would drop all claims against each other, and that the Sheikh Mohammed parties would continue to pursue the other defendants to judgment, would thereafter use their best endeavours to effect a recovery, and would pay the Solon parties 50% of the net recovery, subject to a maximum of £500,000. Lords, just skipping ahead to page 494. Well, 493 is where he starts quoting from the terms of business, but at the top of 494, payment is due to us within 28 days of our sending you a final bill. We will charge you interest at 15% per year. Paragraph 5, there was some discussion before me to respect to those provisions, and he returns to those. He then sets out the costs of the solicitors, and then paragraph 8, 495 at the bottom, about halfway through the trial, Mr. and Mrs. Solon gave a second charge over their house. And then page 497, paragraph 11 are the relevant provisions of the charge. And at 498, Top of the page, subparagraph 4, clause 8.3 contained a covenant to pay the debt, including interest thereon, both before and after any demand made or judgment obtained at the rate of 8%. Paragraph 13, he refers to the settlement agreement. And then I think we can go forward to 501, where he quotes section 73.1. He then sets out certain principles at page 502. Paragraph 22 on 503, he says the solicitor has no absolute right to a charging order. However, there's constant repetition in the authorities of the justice of a solicitor being given such an order. Few such citations will suffice. And he refers to Reborn and Groom and Cheese right, and then Roman Haas. And then he says, paragraph 23, were it not for the contention that Clifford Harris had waived their section 73 right, I would have had no hesitation in exercising the discretion in favour of them. Paragraph 24, so the issue which I have to decide is whether they waived their section 73 right by taking the charge. In the case of a solicitor's common law lien over the client's documents, there is a well-established, although perhaps somewhat arcane principle, that a solicitor who takes alternative security from his client for his costs may be held to have waived his lien. And then paragraph 25, you see Ms Harman's taking the same point that she did on the summary judgment application, that there's no reason why the principle should apply to the equitable right, and he says, no, that's not right. And I think we can skip over to 29. What then are the circumstances in which the taking of other security will be regarded as a waiver? It's often said that this will be the case if the security is inconsistent with the lien. He also cites from Cordery and says there's no suggestion of an express reservation. And then 30, Mr Marshall's primary submission was that the taking of any alternative security of substance and value without an express reservation of the solicitor's existing rights would be sufficient for waiver. There'd be no further requirement for inconsistency. He said this was supported by the rationale for the waiver principle found in the authorities, namely that it was the duty of the solicitor to tell his client if he intended to retain his lien, and if he failed to do so, it was assumed that that was because he did not intend to do so. This is important. So this was Mr Marshall's primary submission. This is not a new controversy. Precisely the same point was considered in Re Morris. And then he quotes from Re Morris and then says, halfway down page 507, the question on this issue, therefore, is whether I should prefer the views of the majority or that of Lord Justice Kennedy. Paragraph 32, he refers to Taylor, sets out the passages we've looked at. Paragraph 35 on page 511, he refers to Groom and Cheese right, and he refers to the quotes from the judgment of Mr Justice Kekowicz. And then halfway down he says he therefore places the decision squarely on inconsistency. Mr Harman submitted that the inconsistency in this case lay in the fact that the solicitor was asserting two rights over the very same property, one of which, the mortgage, involved accepting that the trustee should have his costs as a priority, and the other of which, the statutory charging order, was an attempt to avoid this consequence. This is factually so, and no doubt justifies the actual decision. The taking of security on the same properties as comprised in the lien is one of the examples of inconsistency given by Lord Justice Buckley. But as I read his judgment, Mr Justice Kekowicz was not relying upon this, but on a general principle that for a solicitor to take any security was inconsistent with retaining any other right to payment. He did not, however, appear to have had retailer cited to him, and I do not think I can prefer his reasoning to that to be deduced from retailer as explained in Re Morris. He then refers to the Douglas Norman case, and then paragraph 37, he refers to Twig Farnell. 6 lines from the bottom, Lord Justice Mummery, after citing from the judgments of Lord Justices Lindley and Kane retailer, said that there was a substantial and important difference between the case of a solicitor taking security from a client and from the former client. And he quotes from Lord Justice Mummery's judgment and Lord Justice Scheimer's judgment. He says this was clearly based on retailer, which was cited by Lord Justice Mummery as explaining the principle. There is no indication in the report that Re Morris was cited or that the Court of Appeal had any argument as to whether there was a requirement for inconsistency before a solicitor would be held to have waived his lien. And since the actual decision was that no such principle applied to a solicitor already had a judgment, what was said on the point was obiter. My Lords, I'd only point out that Lord Justice Mummery did find that there was no inconsistency. because he agrees with the judgments of the judges below. Mr. Marshall relies on the repeated theme in the cases that an important consideration in the case of solicitors is their duty to explain to their clients the effect of what they are doing. However, ultimately, they can all be traced back to the judgments in Re Taylor, and I have the guidance of the majority in Re Morris, that those judgments are not to be read as meaning that the taking of any security would waive his lien, but only the taking of one that was inconsistent. The analysis in Re Morris, though technically obiter, is the one that I've already said I should be slow to depart from, and I've not been referred to any authority in which it is considered and rejected. I'm bound to follow the decision of the Court of Appeal in Re Taylor, and in my judgment I ought to accept the interpretation placed on that decision by the majority in Re Morris. I therefore conclude that a solicitor will only be held to waive his lien if he takes a security that's inconsistent. Mr. Marshall says that can't be right, as there would then be no distinction. And just pick it up 8 lines down. This argument has a certain logical attraction, but I do not think it can stand with what was said in Re Morris. Both expressly said that solicitors were different from other lien holders, but did not regard this as entailing the consequence that it was unnecessary to find an inconsistency. Rather, it seems to me they regard inconsistency as essential in the case of solicitors as in the case of other lien holders, but somewhat more readily to be found in the case of a solicitor's lien than in the other cases of lien. And if one stands back from the argument for a moment, it's difficult to see why, in principle, a solicitor should be held to have abandoned the lien by taking a security no way inconsistent with it. I therefore reject Mr. Marshall's argument on this point. I think we can then go to paragraph 42 on 515. The next question is whether the charge is inconsistent. Mr. Marshall relies on 2 points. First, he refers to what Lord Justice Kennedy, again in the minority, said in Re Morris, and says that the grant of a charge over land with significant actual value is very different from a right to apply to the court to exercise its discretion. The difficulty I have with this argument is that there is no indication in the majority judgments that that is what they had in mind. The examples of inconsistency given by Lord Justice Buckley are security taken on property already included in the lien, security which gives time for payment, security which gives a right to interest. However, if security granted over another asset was also an instance of inconsistency, it would mean that both the taking of security on property comprised in the lien and the taking of security on property not comprised in the lien would be inconsistent with it, and in practice any security would waive the lien. That is clearly not what the majority thought. In my judgment, what the majority meant by inconsistency is that there is some feature of the security which is incompatible with the lien, such that the two rights cannot sensibly have been intended to subsist in parallel. And then he refers to Calvi, Simpson and Roberts and Jeffreys. Mr. Marshall's other point, however, is of more substance. The charge includes provision for interest 8%. It's well established that a security which makes provision for interest that would not otherwise be due is an example of inconsistency. Mr. Marshall says Clifford Harris would not otherwise be entitled to interest on their fees. That is so notwithstanding that their terms of business provide for interest at 15% on the final bill. He says that provision is unenforceable in the light of the admitted fact that Clifford Harris did not specifically draw it to the attention of the Solent parties. He then deals with that, which is not an issue that arises in our case, and we can pick it up at page 520, paragraph 50. I've come to the conclusion on this aspect of the case, Mr. Marshall's arguments are to be preferred. I consider that I'm bound by Liddon and Moss to hold that a solicitor cannot enforce a stipulation for such interest against the client unless he established that he informed the client that the law would not otherwise enable him to claim interest. It follows that Clifford Harris had, in my judgment, no enforceable right to claim interest. So, in that case, the result is that no right to interest under the retainer, right to interest under at 8% under the charge, and therefore, following Roberts and Jeffrey, following Re Taylor, he found that that was a material inconsistency, and therefore there had been waiver, but he then deals with another argument about reviver, which the Lordships are not troubled with, but he finds paragraph 35 onwards that there was an equitable charge. So, my Lords, I'm conscious I've sort of run through those, but those in our submission are the relevant authorities one also has the judgment...
Just before we leave it, just to note paragraph 40, the judge tells us at the end that his view of the authorities is that the solicitor will be regarded as having waived his rights unless he expressly reserves them. And I think that follows from what he says in the previous sentence, that waiver will be inferred unless the solicitor explains the position to his client.
So, my lords, there is quite a large measure of agreement between us as to what the authorities show. First of all, there are essentially two stages to the test. Can an intention to waive be inferred from the circumstances, and in particular from the taking of a new security that is inconsistent with an intention to retain the lien? Secondly, was the lien addressed by the terms of the parties' dealings so that it can be said it was reserved? My lords, that is in effect what is said in paragraph 61 of the Court of Appeal judgment, this two-stage test. The Liquidators, it's page 142 of the key documents bundle. My judgment, therefore, Candey will be treated as having waived their equitable lien if one can infer from the inconsistencies between the terms of the new security that they intended thereby to abandon their lien, and if they failed to reserve that lien.
I'm so sorry, which paragraph?
It's paragraph 61, my lord.
On page 142?
I think it's 216, actually, of the electronic
it
file.
depends which bundle one's looking at. Sorry, I'm looking in the key documents bundle, not the...
In the main electronic file, I think it's 216.
Thank you. Yes.
My lord, the Liquidators addressed the second question first, the question of reservation. We follow the same approach as adopted by the Court of Appeal, and that's how I intend to do it orally, which is to address inconsistency first. Second point of agreement, as far as the intention to waive is concerned, that's to be determined objectively. It's acknowledged in paragraph 21 of the respondent's case. Test is whether an intention to waive can be inferred, taking into account all the circumstances. Not every security will be sufficient to destroy the lien. A new security that can exist in parallel with the lien will not enable an intention to waive to be inferred. But where there is a feature of the additional security that is inconsistent, that may found a basis for inferring an intention to waive. As for the burden is on the respondents, the liquidators, to show an intention to waive, but if that burden is met, the burden is on Candey to show its rights were reserved. And that's set out in paragraph 62 of the Court of Appeal judgment. But, my lords, there's very little analysis in the authorities as to why the test is what it is, why it differs from normal waiver principles, which would require an unequivocal representation and knowledge of the essential facts which have given rise to the existence of the right, which it is alleged has been waived. My lord, as I pointed out, most of the cases are concerned with the possessory lien. In the possessory lien, as I've already submitted to your lordship, one can see that it's easier to infer an intention to waive if the solicitor has the documents in his possession and then says, but you don't have to pay me for 3 years as long as you give me a security over your house. One can see that in those circumstances, having taken that security over the house, having given 3 years to pay, perhaps having got a right to interest as well, he can't hold on to the papers. That's very different from the equitable lien. My lords, just considering briefly
Well, is it that different? The equitable lien gives the solicitor a right both to receive the fruits of the litigation himself as a kind of chargee, an equitable chargee, and then immediately to pay himself his outstanding fees and costs out of those receipts. So if you like, it bites, I don't want to use the word crystallises, it bites once the fruits of the litigation have become a fund which are capable of being transferred to him. It doesn't depend on the transfer.
No, but the fundamental difference is in effect that the right, the possessory lien, the right to it has plainly accrued because he's holding on to the papers. He says, I have this right to hold on to these papers. In the situation of the equitable lien, until there is a settlement or judgment, until there's been a recovery, of course, we know from your Lordship's judgment in Gavin Edmondson, there is this equitable right before then, but there is no right that's accrued that enables the solicitor to go to the court pursuant to Section 73 to say, please grant me the charge.
Depends on there being some fund.
Yes, a recovery. Yeah, and that is, in my submission, a clear difference. And one can see why, in the case of the possessory lien, it is easier when alternative security is taken to infer, if there's the necessary inconsistency, an intention to waive. And, my lords, there's a further point which concerns knowledge. In basic waiver cases, one needs an unequivocal representation, but we accept that that can be inferred from conduct or whatever. So that is really dealt with by the first limb of the test set out in the authorities. But you also need knowledge. You need knowledge of the relevant facts and of the right that you're waiving. Now, knowledge isn't mentioned in any of the cases. Now, that is probably understandable in the case of a possessory lien. It is also understandable in the vendor's lien cases that my learned friend refers to, because there's no question of a lack of knowledge. The vendor knows the property's been sold, he knows the purchase price, and he knows he has a right to it. The solicitor knows he has a right to hold on to the papers. But the position becomes more complicated in an equitable lien case where there has been no recovery. And this is a point we make in paragraph 42.2 of our case. In those circumstances, at the time when the deed of charge was entered into, what my learned friend is saying is that Candey waived their right to apply to court to enforce its equitable right that is charged pursuant to Section 73. But at that time, Candey didn't know what it was waiving, because at that time there had been no recoveries. So that in effect, what your lordships are being invited to do is to infer an intention to waive something that was unknown. Yes, Candey knew they had the right to the recoveries, but they didn't know what they were. And knowledge, as we all know, is an important ingredient in all other forms of waiver. And in my submission, there's no reason for saying that knowledge has no part in this type of case, albeit I accept it will only be in the equitable right under Section 73 type of case that it will become relevant, and only then when the waiver is alleged to have occurred before there were any recoveries. My lords, then, and I think I've dealt with this, in our submission there is, I accept, there is reference in the authorities, we've seen it, to solicitors being treated differently. But in my submission, there's no analysis as to why. I know Lord Reid will say to me, well, it's the fiduciary duty of disclosure. Well, if that's what it is, then I fall back on the proposition that therefore, on the first limb of the test, the objective exercise of seeing if there's an intention to waive, there's no reason for treating solicitors differently. On the second limb of the test, as a matter of principle, one might seek to hold solicitors to some kind of higher standard than you would hold the innkeeper. But, in my submission, it's difficult to see how it could ever make any difference. Because the question of reservation, particularly if Lord Stevens is right and taking account of the passage that Lord Reid just referred to me, your lordships were to find that there's no scope for an implied waiver. An implied reservation. But either there was a reservation or there wasn't. And that doesn't matter. That doesn't turn upon whether or not the person reserving is an innkeeper or a solicitor. And therefore, in my submission, whilst I accept the references in the authorities, and in my submission those are all directed at the question of reservation, whilst I accept there are those references, in my submission there is no reason for treating solicitors any differently.
There's one reference in the authorities to, on the first limb, potentially treating solicitors differently on the basis that it might more readily be found that there were inconsistencies. Was there only one such authority?
Yes, I think it's Ree Morris. I'll check over the journals.
Yes. Yeah.
But it depends, my lord. It depends how you read the relevant passages that we've looked at.
I think it's Mr. Nugee, isn't it? Who says
I think you're right, my lord. Yes, yes, it is Mr. Nugee.
Right.
But it depends how you read the passages that are cited in the Court of Appeal judgment and in both of our cases. But in my submission, when you look at retailer, if you remember when we went through it, I pointed out in the judgment, such a security as this, or a kind of security as taken in this case. And one sees that in David Richards' judgment, he emphasises those. And what he, in my respectful submission, is getting at is that, therefore, those comments about solicitors being treated differently are in the context of the court having already decided or assuming that there is the necessary inconsistency. i.e., stage one has been dealt with, and now we're dealing with stage two. Now, my lords, there is a further point of distinction in our case, which is that, as your lordships know, clause 1 of the fixed fee agreement provides that PHRL is to take and has taken independent legal advice. And my lords, if I can quickly show you the evidence in that respect. There's the first witness statement of Miss Turnbull, who was a director of PHRL. That's in the core bundle, tab 7, appendix 6, page 299. The statement begins at 293. But if we pick it up at page 299, at the bottom of the page one sees the heading Fee Agreement and Candey Charge. And then paragraphs 29 to 32. If I could just perhaps invite your lordships just to quickly read those, but the key paragraph is paragraph 32, where she says, I took independent advice from William Frayne Bell, a barrister and chartered arbitrator of Chambers of Geoffrey Cox QC, in respect of these documents. And I also considered the opinion of Mr. Kenneth Judge.
Perhaps the court would like to read all paragraphs 29 to 32, please.
Yeah. Lords, then there's the witness statement of Mr. Judge, which is behind tab 12, begins at page 319. Over the page at 320, he explains that he became involved with PHRL through his relationship with Mr. Robinson. And in paragraph 5, he says that Mr. Robinson told me he'd not received the monies that were owing to him. He'd invested. In the course of the exercise, I came to review the fixed fee agreement. Paragraph 6, Mr. Robinson and I came to view the fixed fee agreement as the best available alternative funding method for PHRL. And then paragraph 7, my overarching concern was to make sure that Mr. Robinson and Ms. Turnbull understood the nature of the agreement, that come what may, the fixed fee would be due and owing. We agreed that we took specific advice from William Frame Bell. I had a telephone conference with Mr. Frame Bell, and I set this out in an email to Ms. Turnbull, dated the 27th of September 2015. And you can see what that says. Concluding, therefore, this fixed fee agreement is not without its risks. If PHRL, for whatever reason, fails to meet its commitments, leaving it with a large preferentially secured creditor. Having discussed this, Mr. Robinson agreed that the arrangement represented the best way forward. And then, my lords, you can see an earlier email. He set out the email of the 27th of September, but there's an earlier email from Mr. Judge dated the 11th of August 2015, which is behind tab 7, appendix 11, page 302. 302.
Thank you.
Dated the 11th of August, and it's to Omar and others. Here are a few observations upon the terms of the fixed fee agreement. You can see what he says, and then the penultimate paragraph. So just to be clear on this issue, once judgment is handed down, this fee becomes an indebtedness which Candey will be insufficient to pursue via the security arrangements that are proposed. And then over the page, 303, he carries on explaining about the fixed fee agreement being in addition to settling the current invoices. And then paragraph numbered 3, finally, I note in this covering note that Candey refers to both a deed of subordination being required from 2 other firms and a deed of charge, presumably a fixed and floating charge, in order to secure priority for Candey's future claims. But I have no idea whether either of these arrangements are to be delivered as a precondition.
Doesn't look as if he saw the deed of charge.
No, if you look at the attachments, which are at the top of 302, this is a point I'm going to make. If you look at the attachments at the top of 302, it's the fixed fee agreement and the terms agreement. There's no evidence that the deed of charge was ever sent in any email to Mr. Judge or to Mr. Frame Bell.
My Lord, 2 points. First of all, these witness statements were served for a different purpose, as you can see from the end of Mr. Judge's witness statement. They were served for the purposes of explaining that the fixed fee agreement was not entered into solely at the suggestion of Mr. Amanat. And secondly, that email is the 11th of August, and one knows that the documents were not entered into until October. And then there's further email referred to in Mr. Judge's witness statement of the 27th of September. So, my Lords, my learned friend does make the point that there's no evidence that any independent legal advice was received in relation to the deed of charge. But in our submission, that is inherently unlikely. The deed of charge, clause 11 of the fixed fee agreement, expressly refers to the deed of charge and says it's annexed to it. Mr. Judge plainly, back in August, 2 months before the documents were signed, refers to the security arrangements. And, my Lords, it's important to bear in mind that it doesn't matter what advice PHRL were provided with. What does matter is that they agreed that they were being advised by somebody else.
Well, in relation to the fixed fee agreement.
Well, I accept that it's referred to in paragraph 1 of the clause 1 of the fixed fee agreement in relation to the fixed fee agreement, but as I've submitted in my submission, it's inherently unlikely that they didn't also seek independent advice in relation to the deed of charge. But, my Lord, you've seen the evidence. It is what it is. But the question then arises, what is the effect of that? In my submission, the effect of it is that we are in the same position as the Court of Appeal was in Twigg Farnell. And if, and I stress if, there is any justification for treating solicitors any differently, for example, in relation to the second limb of the test, and if it matters, which in my submission I suspect it doesn't, none of that matters in this case. So, my Lord, there's 2 points, really. The first is that if Twigg Farnell is right, and a solicitor acting for an ex-client, in those circumstances, the principle, the whole premise of this line of authority simply does not apply, which appears to be what Lord Justice Scheinman is saying. Not so sure about Lord Justice Mummery, but if that's what Twigg Farnell is saying, then we rely upon it to say, why should we be in a different position from an ex-solicitor where we have expressly told the client that we are not advising them, go and seek separate advice? Now, if that's a bridge too far, but it's a submission that's open to me on the basis of the Court of Appeal judgment, if that's a bridge too far, then in my submission, there is no justification for treating Candey any differently from any other person holding a lien. And one simply goes through the 2-stage test that I've been repeating far too often. Now, my Lords, just quickly, if I can refer you to the Court of Appeal judgment in this respect. It's dealt with in paragraphs 50 to 61.
Electronic page.
Oh, my Lord, I'm going to get into trouble because I've got...
Well, it's all right, I've got it. It ends at 216.
So,
212 and following.
212, Mr.
Yes,
Holland. So paragraphs 50 and 51 set out my submissions. They then refer to Twigg Farnell. And then in paragraph 53, Lady Justice Rose says, in the case before him, there was no inconsistency between the taking of the charging order in respect of the judgment, debt and interest and the continuation of the lien. My Lord, that is what Lord Justice Mummery found, but that is important when one comes on to consider the first alleged consistency that my learned friend relies upon, taking a charge over the same property, because there it was over the same property. But then in paragraph, then she cites Lord Justice Shyman, then refers to David Richards, and we looked at that earlier. And then in paragraph 56, she says, in my judgment, this argument does not provide the knockout blow. The argument must be rejected because it misunderstands why equity sets a different threshold for solicitors from that of other lien holders. She refers to Lord Justice Lindley and Lord Justice Kay, and then she says, I do not see that duty as focused on the terms of the new arrangements for additional security. What needs to be explained in a clear and intelligible manner is the combined effect of the new security and the lien on the prospects of the client recovering anything of value to him. Skipping over a couple of lines, the client should be made aware that even though he has now been asked to grant security over the litigation recoveries on the terms of the new arrangements being negotiated with him, the solicitor will have a first call on these recoveries. In most circumstances, the client is facing, in effect, a choice. It is essential that in making that choice, he has a complete understanding of what his solicitor's prior claims to the proceeds of litigation would be if he continues to fight the case. That is what the solicitor is under a duty to explain, and why it's so important that the client understands that any monies he ultimately recovers are subject not only to the security he is now providing to his solicitors, but also to their pre-existing lien. Now, my lords, with the greatest respect to Lady Justice Rose, that is a different test to that set out in Taylor, Morris, Solent. It is in effect Mr. Marshall's first argument that was rejected in Solent, and it is in effect what the minority judge, Lord Justice Kennedy in Morris was saying, because it's tantamount to saying any new security will amount to a waiver unless there is an express reservation. And it ignores the first limb of the test, namely the need to find or to infer an intention to waive. And of course, yeah, I mean, it would mean that any solicitor who takes a new security without expressly reserving will have waived his lien. And that's not what the cases say.
Now, I think that's a suitable point for us to adjourn. We'll sit again at 2 o'clock.
Thank you, my lord.